The register of members. We have been talking about how important it is. How does the public know? How do you as shareholders know who are the members of? Who are the holders of? So every company is required by the Companies Act to keep a register of its members. And we are talking about a physical document, and it is kept in the registered office of that company. You remember we talked about a company having, again, as prescribed in the memorandum, a registered office with a signage that shows the business premises where you are supposed to be located, that if I'm coming to look for that company, I should be able to trace it and find it. And once I find it, in it, what I will also find is a register of members. So it is a requirement of the Companies Act. And if probably an advocate keeps that register for you, it must also be available. If you have provided that, no, the register is not kept at this registered office, probably your registered office is in another town, and you have another office in, let's say you have like 3 offices, and you agree that our advocates may keep our register of members for any other person to be able to see them. You cannot escape what the Act provides. You cannot just assume that saying it's there is there. It must be kept. And what are the contents? So the register must contain the names and postal addresses of the members. And in the case of a company having a share capital, a statement of the shares held by each member, distinguishing each share by its number, as long as that share has a number, and the amount paid or agreed to be considered as paid on the shares of each member. It must also contain the date at which each person was entered in the register as a member. Remember, as we were talking about this, we say you become a member the date you are entered in that register as a member. So the date is very, very key. It is very important. You cannot assume that just because the name and address is entered, it's enough. No. We need the name, the address, and the date on which you became a member. We also have the date one ceases to be a member. And lastly, if this is where the company has converted some of its shares into stock and given notice of the conversion to the registrar, the company shall show the amount of stock held by each of the members. By each of the members concerned instead of the shares so converted. So when we were talking about the names and addresses, remember we said if the company has a share capital, the statement of shares must be provided. So where you convert the shares into stock, again, is where we come here and have that the amount of stock. And you remember you give the notice to the registrar that this member had 1,000 shares. Of the 1,000 shares, we have converted 50 into stock, maybe 100 into stock, and you have that list of whoever has converted them. So we have talked about the location of the register, and the law is clear. The Companies Act is clear that it shall not be kept at a place outside Kenya. We talked about the advocate may have it, but it should not be anywhere outside Kenya. You remember the Companies Act talks about registration of companies in Kenya. It's the Companies Act in Kenya. So for the purposes of that register must be in Kenya. And we had talked about where a company has different offices. If each office has that register, the registrar must be notified where it is kept. We talked about where an advocate decides to keep it for you, probably because you have offices in each county: Mombasa, Kwale, Murang'a, Kiambu. So you decide, let our advocate in Nairobi keep this register for us. You must inform the registrar that our register of members is held in Nairobi by our advocates, someone located on this building, on this floor. We also talk about the index of the members. And a company having more than 50 members must keep an index of these members. Again, this index is kept where the register is. So what we have in the index is that it has the names of the members, unless this index of members is not, it's for companies with more than 50 people, and where the register itself can serve as an index, you need not keep it. So the index contains, in respect of each member, a sufficient indication to enable the account of that member to be readily found. Again, it must be provided, you must indicate to the registrar where you keep this index. So we also talk about the inspection of the register. This register must be kept open for inspection by any member without charge, any other person on payment of a fee. And where a member or any other individual requests to inspect that register, you shall issue, upon the request, the person will be issued with a copy of the register or whatever information that is required. But where the company refuses its register to be inspected and it fails to provide a copy, the company and each of the officers who's in default commits an offense, and on conviction are each liable to a fine not exceeding some amount specified by court. We go back to the essence where we talked about incorporation, and it exposes you to the public. It's no longer about what you want hidden or what you want to prevent others from seeing. In as far as these documents are made public, even if I'm not a member of that company, I can ask to inspect. And once you do not give me that, once I request and you tell me no, I need you to pay this amount of money for you to be able to access and for you to get a copy of that register. So once I pay the money and you don't, I can take you to court because it's a public document that should be made available to all individuals therein. So before we proceed to the changes, what we can do with that register, kindly we take a 5-minute break. We be back by 9 p.m. So we need to talk about why we need that register. So the register is the creditor's guarantee, showing them to whom and what they have to trust. While it is not conclusive evidence, the fact that it's a public document gives more weight and credibility to a person transacting. And this is why we were saying where an innocent third party, having relied on that register, will be compensated, and you as a member cannot go back and claim that you are not a member for that particular transaction. So the reliance to be placed on the register is qualified to the extent that any person dealing with the company must be taken to know that the shares may be transferred in accordance with the articles, that a member, whether he has been induced to take shares or by misrepresentation or mistake, even though on the register for years, while the company is a going concern, may repudiate his name, his shares, and have his name removed from the register. That essentially says, as long as the company is seen to be able to operate in the near future, once you're able to see that your name was entered by mistake, you can have your name removed from that. So what happens when we want to make changes to this register? Bearing in mind it's a public document. So a company may expand from its register members an entry of member relating to a person who was formerly a member at the expiry of 10 years. So what we are saying is that for your name to be expunged from that register, especially in the case where you have not requested or you have not petitioned the court, it takes a minimum of 10 years for the company itself to institute those changes. But where you as an individual have requested the company to expand your name, you remember the example we gave of an individual who essentially never wanted to be part of that company. You can petition to have your name removed, and the company shall issue to the person a copy of the updated register. Where the membership of a company increases from 2 to more, the company will enter in the register of members of the company the name and address of the person who was formerly the sole member, the statement that the company has ceased to have only one member, and the date on which the company changed from having more than one member. So this register will take into effect all these changes. Bear in mind the importance of the dates, because we have said you become a member on that particular date. So it is important that at any date in which the transaction took place, it's noted that the company changed ownership from it increased its members from 1 to 2 or more. If it's a limited company, that register will have the name and address of again the member who was formerly the sole member, a statement that the company has ceased to have that member, and the date on which the company ceases to be that single member company. So any changes must include the name and addresses, the statement. It is essential that a statement is made that the company has changed from this to that, and the date in which these changes occur. We have talked about a corporation or a company being given the chance to order its own issues and affairs. So under Section 118(1), the court is given the power to rectify that register. And it's done in two cases, whereby if the name of any person is without sufficient cause entered in or omitted from the company's register of members, or default is made or unnecessary delay takes place in entering on the register the fact of any person that ceased to be a member. And this application to the court under Section 118 can be made by the aggrieved person or any member or the company itself. And the court again has the discretion to refuse this application or order the rectification of the register and the payment of the company of any damages sustained by the party aggrieved. And this order can be done even when the company is being wound up. In this case of Burns versus Siemens Bros Dynamo Works Limited, it brings out the circumstances set out in Section 118 above. And you need to remember, these are not only the reasons as to when a court can order rectification. It may also do so when a name stands on the register without sufficient cause. So in this case, the plaintiffs, Burns and Hambro, were joint owners of shares in the defendant company. That is the Siemens Brothers Dynamo Works. The shares were entered in the company's register in the joint names of Burns and Hambro. The company's articles provided that where there were joint holders, the person whose name appeared first in the register of members and no other should be entitled to vote in respect of the shares. This meant that Hambro had no voting rights. So the two, Burns and Hambro, sued for rectification of the register so that it may show that the plaintiffs owned roughly half of the joint shareholding. So the court had jurisdiction to make such an order, and the company was required to rectify the register, showing shares numbered 1 to 1,000 in the names of Burns and Hambro, and shares numbered 10,001 to 1993 in the names of Hambro and Burns. So the court may also order rectification by deleting a reference to some only of the registered shareholders' shares. It need not delete his name entirely. And this is referenced by Transatlantic Life Assurance Company. And in this case, the court deleted an additional number of shares which had been issued to the applicant in breach of the prevailing exchange control regulations, but left the register intact as to his previous shareholding. So what that means is that whatever issues we bring to the court, it has the discretion in what to do and what not to do. But it will alter the register where it is on the face of it that an issue has been made that should not have done, as in the case of Burns and Hambro. So Section 118(4) states that if an order is made in the company, in the case of a company required to send a list of its members to the registrar, the court, when making its order for rectification, shall by its order direct notice of the rectification to be given to the registrar. As we have discussed previously, any matters relating to the company, any changes, the Registrar of Companies must be made aware. So the court orders directing the change of the register, though to be done by the company, will be given to the registrar such that it's effected. We talked, this case particularly is where the court can make an order if the company is being wound up to rectify that the membership in that register.